Well, I hope we are ready to resume this session, which I don't think will be very, very long. But there was a silver lining in Mr. Keoseyan not showing up. So that gives us some scope to continue the discussion we had on day one, on Monday. And I don't know whether my colleagues, I'm sure they will at some point. But I, for one, had at least one legal question to pose to both of you on a question which I find very, very substantive and which might be of interest to the tribunal, which is article in NAFTA 1121 concerning the waivers. And I don't know whether someone could be kind enough to show it on the screen. Article 1129. Yes. And I'm going to refer, of course, to paragraph 1, letter B, which reads, the investor and, where the claim is for lawyer, the enterprise, comma, waive the right to initiate or continue before any administrative tribunal or court. So that's the wording of the clause. The investor and the enterprise in the singular form, the enterprise. And this is of interest here because a recognized fact by both parties is that there were two legal entities, Finley Resources and Drake Mesa, who presented before the submission of the request for arbitration their waiver but there was another entity, Drake Finley Mexico, which didn't, and it didn't do it until earlier this year, in March or whenever. And so the interpretation of the relevance for this arbitration of this paragraph B is disputed. For respondent, this is a condition precedent and is completely, totally relevant and should be applied, as Mr. Bonfiglio told us on the first day, in the most strict form, whereas Clements took a more lenient approach, and just the fact that the paper was missing shouldn't be that relevant. But I would like here to point out to the question that whereas the treaty acts in general terms of the investor and the enterprise, in this particular case we have a few Mexican enterprises, actually two. We have Finley Resources in the US, and the enterprise here happens to be at least Drake Mesa and Drake Finley, and both Drake Mesa and Drake Finley and Finley Resources are part of the consortium, which are the counterpart to PEP under the contract A21. And one of the clauses of the contract says that Finley Resources will be the leader of the consortium, but the three parties will have and that's on this my English is not good enough. They have obligaciones solidarias.
Joint and several obligations.
Joint and several. So under the contract, PEP can go against any of them. So they have a joint and several obligation. But the leader is Finley Resources, even though when the contract uses the singular el contratista, what is meant strictly is Drake Finley, but the contract makes clear that the singular and plural are equivalent, and by contratista may refer to the three of them. And then my question here, which I want to pose to you, is assuming respondents' view were the right one, which is an open question. So under that hypothesis, which is a pure hypothesis, and the tribunal will have to reflect on that, what would be the consequence of that finding by the tribunal, that Drake Finley didn't submit its waiver, and therefore paragraph 1121.1 A-B was not fully complied with? And because if I've read correctly, respondents' contestación a la demanda and paragraph 325, I don't know whether you could show it on the screen, the contestación a la demanda, paragraph 325. Yes. Well, then I got the paragraph wrong. But from reading the contestación, at some point I understood the respondent saying that no claim could be could be accepted for the benefit of Drake Finley. And my point is, and I want to raise this question to both of you, the fact that Drake Finley didn't submit its waiver on time, from the point assuming respondents are right as to the consequences of that fact, what would be the consequences? That the entire claim should be dismissed, or that only the part of the claim concerning Drake Finley should be considered null and void, but not, for instance, that concerning Finley Resources' claim and Drake Mesa's claims? So to what extent the fact that one of the three entities didn't present on time its waiver affects the entire consortium and makes the tribunal lose its jurisdiction altogether, or it just means that the tribunal, under that hypothesis, would not have jurisdiction only concerning claims benefiting Drake Finley? That's the question I wanted to pose to you, because I think that's very relevant for the tribunal. And so probably, I don't know whether you want some time to reflect, or you can shoot straight and respond right away. So if anybody wants to take the floor. I think I made myself clear as to what's the content of the assuming respondents' general thesis about the lack of jurisdiction of the tribunal. What's the scope of that lack of jurisdiction if Article 1121 should be interpreted as respondent does?
Señor Presidente, como
Mr. President, as they say in English, I don't want to shoot from the hip. If you could give me just a moment to consult with my colleague.
It might make sense for you to reflect briefly on this legal issue, which might be important for us. By way of background, I've now realized that I made a mistake in making reference to 321. Actually, is to the paragraph here in front of us, 322, that in Spanish reads, las demandantes presentaron las renuncias y
The claimants submitted the waivers and consents of some of the companies in Documentary Annex 7 to its request for arbitration, but did not include consent or waiver on behalf of Drake Finley. That is to say, the claimants did not meet the conditions precedent and expressly established in Article 1121 of the NAFTA, and therefore, and this is the key phrase, and therefore they cannot present a claim in representation of Drake Finley under Article 1117, and they cannot present a claim for losses or damages to Drake Finley under Article 1116. Now, my impression on reading that paragraph 322 is that for the respondent, what the tribunal cannot do is rule favorably on any claim by Drake Finley. But I ask whether that would entirely deprive the tribunal of its jurisdiction, or would it merely deprive it of jurisdiction in relation to claims having to do with Drake Finley. And I'm sorry about citing the wrong paragraph. Alan? Don't worry, President. The good thing is we found the paragraph. Answering your question, I would say, to be as direct as possible, that this negligence at the time of submitting the request for arbitration, not attaching Drake Finley's waiver, has as a consequence that the tribunal does not have jurisdiction to hear claims with respect to this entity, Drake Finley. Now, allow me to simply make a generic clarification. The jurisdictional objections raised by the Mexican state here operate in layers. If the tribunal considers that the first layer, which is the improper self-consolidation of the two cases, if they think that it can be resolved in this arbitration, then the first consideration the tribunal should have is that Drake Finley is only relevant for the case under Annex 14.6, which has 14C, which operates in place of 1121 of NAFTA. Now, years went by, the tribunal should consider, since the request for arbitration was submitted, for the claimant to cure this very serious error, which has the effect of the Mexican state not giving its consent for claims around Drake Finley to be resolved under Chapter 11 of the NAFTA. And not just that, let us hear what one of the non-disputing parties of NAFTA said on Monday. The United States. This is a very serious mistake, and in particular, it should be analyzed, as we also said, in a rigid and clear-cut manner. This provision, which we see referenced in paragraph 322 of our memorials, has been analyzed for the more than 20 years that Chapter 11 of NAFTA was in force, and tribunals such as KBRV Mexico and other NAFTA tribunals have reached this conclusion, that this serious omission cannot be cured in the course of the arbitration, which the claimants have tried to do. So, before consulting my colleagues as to whether they want to include an additional point, answering your question, Mr. President, in effect, the fact of not having properly presented, in keeping with Article 1121 of the NAFTA, Drake Finley's waiver, has as a consequence that the tribunal should determine that it does not have jurisdiction to resolve the case with respect to this entity, Drake Finley. I don't know if my colleague wants to add something. Well, the thing is, you say to resolve the case with respect to said entity. Do you mean that the tribunal lacks any jurisdiction, or just that it cannot make any decision that would benefit Drake Finley?
You want to get to what the practical impact is at the end, obviously. So, for example, then, if the claimants cannot bring a claim on behalf of Drake Finley, then obviously the treatment of purported or alleged treatment of Drake Finley can't form the basis of a ruling. It also means that Drake Finley can't be treated as though it was an investment, is the basis for bringing the claim. And so we would need to know what are the purported assets of the Mexican entities that belong to Drake Finley, because they're not in this case. And so in that sense, and this issue of what is the investment, it could have a broader impact.
Yes, I think if Drake Finley were the only party to the 8-to-1 contract,
Yeah.
that would be pretty clear. But it so happens that the contractor in the 8-to-1 contract is a combined one. It's a consortium in which the leader is not Drake Finley, but is Finley Resources. And so my practical question emerges. What's the consequence if you concentrate on just one of the three members of the consortium, and what are the practical implications of the tribunal not having jurisdiction on that particular member of the consortium?
Well, Mr. President, we've been discussing a lot of hypotheticals. So let's have a hypothetical that Drake Finley Mexico is the entity that owned all the assets. And we have not conceded yet that we don't plan to concede that they've established ownership of particular assets or equipment. But let's say it was just Drake Finley, and Drake Finley was the only one doing the work. That would impact your analysis of whether they've met the actual investment criteria to establish jurisdiction.
You know, we agree that you wouldn't throw out the entirety of the claim from all the claimants. I'm glad we can come to that agreement. I think when you read Article 1121, it would mean that the investor who is bringing the claim on behalf of Drake Finley, where that claim is for the loss or damage of its interest in Drake Finley, if Drake Finley did not submit a waiver, that claim would be out. That would be the logical outcome, which I think is what I heard from Mexico too, but not the entirety of the claim from the other claimants. I think that's a straightforward reading. Now, I would just add, just as a somewhat of an aside, it would have been, and I appreciate the comments of the timeliness of submitting a piece of paper. It would have been helpful to receive these objections as we agreed in the procedural order up front. Remember, we had a process where Mexico, if it believed in its jurisdictional objections that we heard, it could have proceeded that route, but it didn't. We would have been able to shorten the time frame of curing, if curing is allowed. I appreciate that's something for the tribunal to decide. That would have really helped matters, and I would say minimize the drama when it comes to the time period.
Please.
Yeah, no, we just have to go back to, if we can project it here, Article 1121, paragraph 3. Right. A consent and waiver required by this article shall be in writing, shall be delivered to the disputing party, and shall be included of a submission of a claim to arbitration. And that's an express requirement. And whether or not they ended up submitting it 6 months late or 2 years late, or in this case, 4.5 months after Mexico brought up the issue in its counter memorial, I think to us is really beside the point.
If I may, this was within the past 2 or 3 years. There is a tribunal, I think it was BMEX, that was presented with this very similar issue. From what I've read, the awards that have been utilized by Mexico to impose a draconian issue that can be easily cured are awards where the investor either tried to couch its consent with all types of caveats, where it had either pending proceedings or planned pending proceedings. I would encourage people to read the details of those awards that are being relied upon for this premise.
This is going to be like a tennis match, so feel free
I'll be very, very,
to
very,
hit back.
I'll be very, very short. We just have to sort of draw attention again to paragraph 3, and you'd have to basically strike it out and totally ignore it to allow a party not to comply. Thank you.
Yes, we'll just show you one, which is CL
17.
17, and it's International Thunderbird, and they were faced with this exact issue, which the difference here is, and everyone that's wrestled with this has wrestled with this same fact. Is it form or is it material? You see, if you have a concurrent proceeding in Mexico, against Mexico, that's a material violation of the article. But if you have discontinued your proceeding, as we have here, as Drake Finley did in Mexico, then it's no longer material. And whether or not you take that piece of paper and you submit it with your claim, that doesn't mean that let's say you don't do that. That doesn't mean that you violated what the article says. It's a mere formality at that point, because the real crux of that rule is to discontinue your proceedings. And we did that. Drake Finley did that. So if you read what Thunderbird said when faced with those facts, and the last 2 paragraphs I think are the best, it joins the view of there's others. BMEX is, I think, even later than Thunderbird, that are going to say the same things. Taking the position that Mexico is taking here is entirely, or excessively technical when you've discontinued it.
Yes, many thanks. That's why I wanted upfront to narrow down the scope of my question, because I know that on the fundamental issue of how the provision should be interpreted, there are conflicting views. And even if you keep discussing for 10 hours, but the question is, the real question that I was raising is, assuming the tribunal were to side with Mexico's interpretation of the clause, what would be the practical consequences in this case, in which the enterprise, singular, in the article, in a case involves just 2 entities, Drake Mesa and Drake Finley, not to speak of the American Finley resources. So at any point, even if the tribunal sides with Mexico on the interpretation of the article, some secondary interpretation will be necessary to be made concerning the practical implications of only Drake Finley having not submitted the waiver. That was the point I want to flag, because definitely that will be something for the tribunal to consider. I have another issue, but I don't know if in the meantime my colleagues, for the time being, they don't have any question, and which is concerning to something which we discussed briefly, and which have just been mentioned by Mr. Bonfiglio, is the concept of self-consolidation. Today we heard a new term, alegaciones de oreja, which for me was new, and not today, but on Monday I heard this concept of self-consolidation, which that brings me to the question. Typically, or until I heard that expression, self-consolidation, I would tend to think that consolidation is about you have 2 separate proceedings going on, and the question is to what extent someone can ask for those proceedings to be merged, which is different from one or a group of claimants in their claim using a number of legal bases for the claims and having many claims, which in my experience is very common. In many cases, you have either one single claimant or more than one claimant, including in their claim a number of claims based on different legal provisions, and in this case are legal treaties. So the question is, to what extent the articles in NAFTA and USMCA on consolidation apply to the concept which you have described, respondent, as self-consolidation, which is just one procedure but with different legal bases. Are those not different concepts? Consolidation, I would tend to think that is consolidating separate proceedings into a single one, whereas you think that self-consolidation applies when you have just one procedure with different legal bases. And I would like to open that question for contradictory discussion between the parties.
Gracias, señor presidente.
Thank you, President. Those are novel aspects because the Mexican state has never, and none of the parties to NAFTA and TMAC and the USMCA had ever confronted such a situation, in the sense that different claimants presented different claims under different treaties in a single case. Let's not forget that NAFTA Chapter 11 includes a provision on consolidation or joinder, just as Chapter 14 of USMCA has the same. But at the end of the day, at no time was the claimant required to consolidate the claims. And the thing is, they're under different treaties. So while in commercial arbitration, for example, there can be joinder of parties or a consolidation of arbitrations into a single one, here we mustn't lose sight of the fact that these are different claimant investors for different claims, different facts, and I have to repeat it once again, under different treaties. Mexico has faced cases in which consolidation has been sought in light of the provisions of the same treaty, but not under different treaties. And this makes claimants' claim deficient because neither the United States or Mexico or Canada, when they signed NAFTA and when they signed USMCA, they did not give their consent for this to happen. So what we see here is very problematic, and clearly this has as a consequence, since we submitted our memorials, that it would be appropriate for the tribunal to determine that it does not have jurisdiction.
To article in NAFTA, 1126, paragraph 2. And paragraph 2 reads, where a tribunal established under this article is satisfied that claims, here is claims, and one of the key issues is what is meant by claims here, have been submitted to arbitration under Article 1120 that have a question of law or fact in common, the tribunal may, in the interests of fair and efficient resolution of the claims, and after having the disputing parties, by order, assume jurisdiction and determine one or more of the claims, to consolidate the different claims. So one can think that by claims, in paragraph 2, is meant claims submitted in different proceedings. Or alternatively, you could think that claims here include claims submitted under one procedure. Mexico's view is that these claims in the first line of paragraph 2 refer to also to claims under one single procedure. But my question is, couldn't you think that by these claims, on the first line of paragraph 2, what is meant is claims in the sense of claims submitted in separate proceedings that you are trying to, you maybe authorize to merge into a single procedure precisely because in the interest of fair and efficient resolution of the claims?
Mr. President, this article isn't referring to this tribunal. If you look, you have to make a request to the Secretary General to form another tribunal to decide make the decision on consolidation.
Sorry, could you repeat again?
If you look at paragraph 3, a disputing party that seeks an order to have two claims consolidated has to request the Secretary General to establish a tribunal to make the decision on that.
Yes. But actually, paragraph 3 would buttress the view that here what we are thinking about are different procedures that someone wants to merge, which is not the case here. So here we have a different. So to be clear, one thing is one single procedure with different claims hanging around, and a second scenario is two separate procedures with some commonality which calls for a potential merger or consolidation.
Mr. President, I think this is coming down to what you define as a procedure. So Mexico's position that claims brought under two different treaties with different claimants involving different contracts and different factual circumstances are not one proceeding, right? I mean, you could, you know, you could imagine you could really stretch this out and have claims brought under three different treaties or, you know, even many more claimants. And the point is there's no procedure for doing that, right?
Perhaps I'm applying a commercial arbitration point of view. 1126.3, doesn't it apply to, there's a case law and French case law where you have multiple parties and then it's the institution that appoints the whole tribunal because possibly one party cannot participate in the constitution?
No, sir. It refers.
We're in another situation here. It's, when you say the Secretary General to establish a tribunal, does it mean that in that case you don't have a mechanisms where the parties can choose a arbitrator, but it's the Secretary General that appoints each and every member?
No, if you look paragraph 3, it says a disputing party shall request a Secretary General to establish the tribunal.
But what is the meaning of establish a tribunal? Does it mean that the Secretary General will then be it's going to be ICSID that appoints all of the three?
Well, the parties could agree on the tribunal members, and if not, then yes, it's up to the Secretary General to appoint them.
Yeah, that's.
And one question concerning the practical implications. This is a question which I had time to raise the other day of that interpretation that one claim, one procedure. Because otherwise, if you use different treaties, your point is that if you are pleading under two different treaties, you should separate. You should deconsolidate, so to speak, the proceedings. But what's the efficiency, rational, of that? Or in other words, to what extent you are disadvantaged by the lack of deconsolidation of claims with a different legal base, rather than going beyond the letter and the interpretation. I'm trying to figure out what's the rationale in terms of either due process or fair and efficient resolution of claims of the alternative interpretations. And what's the going beyond the letter of the article, the rationale for having separate procedures as soon as you base your claims on different treaties?
Could we have a moment?
Yeah, sure.
Thank you.
One point to follow up on my remark to Mr. Becker. The case law that I was referring to, famous case is the Dutko case, which is a French case, where essentially the situation you have is a variety of parties with a variety of institutions, a variety of rules. In that moment, you might possibly you will have great difficulties of consolidating. In that moment in time, you'll have the institution that steps in and appoints and establishes tribunal. And I think 1126 provides precisely, if you see further down, it's number one, it will be a tribunal established under the ancestral rules, and then the Secretary General appoints 3 arbitrators. So it's not a situation how we have it here, where each party appointed its arbitrator and then a third one was appointed.
With respect, we disagree.
Mm-hmm.
It's not the situation as it was in that other case, because parties bringing claims under an individual treaty have very clear terms of how to set out whether they have jurisdiction or not. There's no intent or language in the NAFTA or the USMCA that discusses that we'll just be very flexible and waive procedural requirements so that we can combine separate claims. I mean, you have a duty, if you're going to bring a claim, to ensure that you can meet the requirements for doing so. Mm-hmm. And it's a process that's driven by the disputing parties, not by the Secretary General. In fact, the Secretary General will, I think, will agree, well, generally avoids getting into making decisions on jurisdiction.
Sure, but you accept, if you read further down, you will see that the kind of situation we have here would be a different kind of appointment than what took place in this case.
Well, again, there was,
Correct?
again, they
I
took,
mean, you look at paragraph 5, that's
Yeah.
not what occurred in this case. And
That's
we're
right,
not
because there's-
and
but
we're
there's-
not proceeding under the UNCITRAL rules either.
no, but they should have requested, if they wanted to bring two cases and then attempt to consolidate them, our point is they should have asked for that,
Sure,
instead
but
of just self-help.
you could also say you consented to it because you went along. You could have
No,
objected.
we've
and insisted
objected
on-
from the very beginning.
But did you ask for application of this article?
Si pudiera, señor doctor Stinnerman,
If you allow me, let me go back to the draft of this article. Claimant and respondent may agree that both parties, as well as the tribunal, would like to have a fair and efficient resolution. There are no doubts about it. Both parties want that, but the problem is the way in which we are in this arbitration, and it has to do with the initiation of the claims, such a disruptive way in which it was done. On the one hand, we had the need to present 14 jurisdictional objections, and the worst of all is that claimants did not even take the time to implement, to have this Article 1126 apply. So we should not lose sight that, and this is something that I would like to convey to the tribunal, that this is a right that the law to be applied is different, the one that needs to be applied to this dispute. We're talking about disputing parties, at least in the case of the claimant. They're different. Mexico is facing a case against different parties. On the one hand, there are claimants under NAFTA and different claimants under USMCA for different reasons. So, answering your question, Mr. President, as to efficiency, there hasn't been any, because the number of jurisdictional objections that we had to present speaks for itself. And the truth is that consolidation was never considered by claimants. Also, we object to that, and it is reflected as the first objection in our memorials. And that's what I would say.
This discussion, the fact that the USMCA is the successor to NAFTA, so we are talking about two treaties, but in fact it's not a consolidated treaty, but it comes pretty close to, yes, there is some continuity between NAFTA and USMCA. You may recall that the other day we discussed about the meaning of Note 21 of USMCA, and the claimants argue that they didn't know whether to submit the claim under NAFTA or the USMCA. They called the State Department. So is that not a relevant factor to take into account? The fact that they are not claiming under NAFTA and under a bilateral treaty, but they are claiming under two treaties which are intermingled and intertwined, and one is the successor to the previous one. Please, Señor Bonfiglio, adelante.
es un excelente.
Mr. Bonfiglio, that is an excellent question, but we need to be specific about two different things. First, the commercial, the business trilateral relationship that we have in the northern area. It has been going on for more than 30 years, and we have a free trade agreement. That is the continuity, the product of NAFTA moving on to USMCA. Something different is to have two different treaties with two different dispute settlement resolution mechanisms, and also with a dispute settlement resolution, which is different because Section B under Chapter 11 is not the same as the dispute settlement mechanisms under Appendix B and D under USMCA, 14D and E rather. So I understand that there might be a business continuity. This is not a formality. We're talking about a different treaty. There are some entries that are enforced that are different. There are specific provisions. I would say that this treaty is a new generation treaty, such as USMCA is the result of the consent of 3 states. I would not say that there is continuity regarding merely legal aspects because they are different treaties. There is a commercial relationship, a business relationship that survives the treaties.
Okay, there is Annex C about legacy investments, and the second treaty allows claims to be submitted in keeping with the first treaty. So in the second treaty, there is an explicit recognition of a link through legacy investments to the first treaty. So they are, I wouldn't say they are twins, because one was born after the first died. But I think they're pretty close together, and to that extent, they are different treaties, but in a limited sense. I want you to challenge that view.
Es una pregunta compleja. Nos regalaría un minuto.
It is a complex question. May I have a minute?
I think they are going to be relevant no matter what for the tribunal, and of course you will have plenty of time to think it over and plead on this in your post-hearing briefs. But we have now the privilege, thanks to Mr. Kyoseyan, of having time to elicit your views on these questions, and that's significantly for the benefit of the tribunal to have this possibility of playing tennis with the two teams on these key issues.
I'll tell you what goes when I look at the various awards that have addressed challenges to what's been termed as consolidation. I agree with the notion that the articles that we read are really for, if you will, two stranger arbitrations that maybe a host government feels the need to consolidate those so it keeps consistent decisions coming from two different places. I can appreciate why a host government would seek an application under 1126 to avoid inconsistencies. When you have, as you said, Mr. Conte, when you have successor treaties in a very narrow, and this is not going to last forever, you have a very narrow time frame because claims under NAFTA are now dead. You can't bring them as of July 1, 2023. So the tribunal finds itself in a very rare circumstance. This is not, I don't have privilege to the filings, but I don't think there's another case where that's going to see these sets of facts. And I'm a little perplexed at the outcome of what the suggestion would be that you can't consolidate claims under successor treaties. What would that result in? I assume the result would be the three of you would then be seated before a NAFTA treaty arbitration and a USMCA treaty arbitration. Or would you have to start all over again for your treaty claims and have different tribunals hearing different claims, which on the same set of facts, because the facts are the same, and that's going to lead to inconsistent decisions. So I appreciate we're in a novel circumstance. I'm not sure that the treaty parties envisioned a system that would prejudice the investors who are caught in the crosswinds of a transition between the treaties. I would note, the U.S. was here, Monday? Said nothing. said nothing about that. If this were an important issue, we would have heard it from the United States when they came on Monday. They didn't. And the best thing that an investor can do is try to present it, and I think it's pretty common in most legal jurisdictions around the world, although I'm not an expert on everyone, that you want to have one tribunal hear a consistent set of facts and come to a conclusion for effectively the same parties. I've heard they're different parties, but they're really not here. It's the same parties, same set of facts, the same claims under basically the same treaty. And that's all I got.
May I follow up? I think what I at least would be interested is to hear as to whether the case law that were cited by the parties, how they apply in this new circumstance where you have two treaties, right? So I understand that the case laws that were cited apply to a NAFTA situation. And here we have the novel issue that there's a, consolidation, although I don't think that's a proper term, brings in a new treaty, and then comes in Mr. Monfilio's argument that you need to have the consent. Now I could imagine, and I would at least be interested to hear as to whether in that case law that pertained to the NAFTA situation, there is ratio legis, reasons that may be used that are overarching and may also apply in the situation we are in. I would also like to hear as to whether there are other overarching principles of international law that would allow the tribunal to address the situation, like what you said as to what is the overall goal, not to create inconsistent decisions, etc., and what are the underlying principles of public international law that should guide us. So we have this case law. It applies only to NAFTA. You could perhaps also say that case law shouldn't apply here, right? Because you need to address the situation that there's a different treaty, and you need to establish party consent.
And a fair point, and we'll take it and do the investigation and put it in a post-hearing brief. I am curious, what's the resolution to the issue? Take it a step forward. Assume that you can't consolidate. What does that mean? Do you keep one claim? Both claims and hear them separately? No claims? I would suggest you need to keep, I've read at least one of the awards that says you at least keep some. I think it was an Argentine bondholder award, if I'm remembering correctly. That tribunal was presented with, in the factual scenario, a host of bondholders, or I think it was bondholders, that were claiming against the Argentine government. And these groups of bondholders could be grouped together, but their claims depended on different facts or differing facts. And that tribunal was confronted, if you want to analogize to this case, I don't think it's a comparable, but let's assume. That tribunal said, okay, we got to hear something, so let's pick the one we're going to hear and move forward with it. I'm assuming that's the logical extension from the argument that was presented about this consolidation objection.
So are we finished with this consolidation thing?
Sure that Mr. Becker.
Por el momento no tenemos más que.
For the time being, we have nothing to add.
Parties. And I have one question which is not related to the treaties, but to a substantive issue which was mentioned this morning by Mr. Lustano, and I myself flagged the issue on day one, which is the proceedings in Mexican courts concerning not the civil case but the administrative case. And then for that, I just wanted to make sure that concerning what arguments claimants made, claimants' attorneys, which at that time were not you, but whoever they were, made in Mexico in support of the request for the rescission to be declared null. I think we've got your initial claim in Mexico, which, as far as I know, is document R44. R44, which was submitted by respondent, and is the demanda that you presented in Mexico. Luckily, this is not that long. It doesn't run into the 100 pages. It's 60 or whatever. And as far as I know, I've seen the arguments made by the claimants. There are long pleadings about the notification process, the lack of power of Mr. Gomez to declare the contract rescinded. There is also contractual credit exception, non ad impleti contractus. And then there is some minor reasoning about PACMA. So, and that's why this question is mostly addressed to the claimants, but of course, respondent will be welcome to join the discussion. I would tend to think that the statement that Mr. Lustano said this morning, that in that claim in Mexican courts, in the purely administrative case, you never raise, I mean the claimants never raised under neither clause or letter R of clause 15, nor the fact that the work order was a fake one, as you have been claiming. So in this arbitration, in paragraph 73 of your reply, you make an eloquent argument about why the judge made the wrong call when dismissing your claim. But I think that paragraph 73 goes well beyond whether your Mexican lawyers argued in Mexico in the proceeding leading to the sentence of October 4, 2018. And I just wanted to check whether there's any misconstruction or any misunderstanding or any mistake in that conclusion, which I, on a preliminary basis, I have drawn from reading papers and listening to Mr. Lustano and myself going into this claim in document R44. So claimants are invited to comment on that if they wish.
Mr. Conte, we were going to address this tomorrow when we had a conversation with Mr. Asali, but I'll give you 2 points without giving a great big preview. Mr. Amescada, as you duly noted, he believes that the court had a duty, regardless if the claimants in that administrative rescission specifically raised 15.1R. I will tell you, we are currently, at the moment, trying to obtain a document for you for the tribunal, which I appreciate will have to go through a round of special permissions and fight over the document. But there's a document called an alegato, which maybe some people have seen, maybe some people have not, that was presented to the administrative court that clearly references clause 15.1R and the complaint that it was not proper to administratively rescind the contract based on one unfulfilled work order.
We'll come to that then tomorrow because that's important. But you mean an oral allegation or a written allegation?
There is a written document that we're having to get my colleagues from our Mexico City office, who are currently lots of paperwork that you have to present in order to be able to obtain a document before a Mexican court. They are currently trying to obtain that document, and we will have it hopefully today, if not tomorrow. But Again, I can make no promises on third parties other than we're doing our best to get it to you.
Well, this raises a question. I'm sure Mexico is going to address this point. But you may recall that in the procedural order concerning these hearings, we said that the tribunal might consider the possibility of, before the post-hearing briefs are submitted, to have a limited and focused round of submission of documents or evidence. From my comments this morning, you may see that something which the tribunal had in mind was those organizational charts of the investors and of the organization of PIP. That's very limited. Probably are you hinting at a new document? So before Mexico objects to that possibility, I think that let's wait for tomorrow, and we'll see. And I don't know whether there are any more substantive issues for us to discuss now. Yes, please, Alain.
Well, thank you. One of the questions I wanted to ask is linked to 15.1R, but we'll come back to that tomorrow. It's okay. Well, I have several. The problem is that I had them 2 days ago. We have lost a lot of time yesterday for bad reasons. And I forgot to work on that. So maybe I ask for your indulgence. Maybe I don't find them as easily as that. So here again, without probably having a very good order. First, question to both parties, and it was partly inspired, I think, by was what Mr. Becker said, said yesterday. It came again and again, but I am still not clear. Where are the trucks, the rigs, the equipment which was bought? Who possesses them? Can be freely used, sold by the owner? This is a question for both parties. We have come back to that from time to time, but I think in a rather confused manner. Question for both parties.
I don't want to get too specific, but I know that there are rigs, workover rigs, that are still in Mexico. There were some rigs that did come back. Now, putting some, I think
Come
that
back
number,
here.
come back to the United States, that number is small. And we can submit more evidence regarding that number. We obviously believe that to be a damages issue, but we can submit evidence regarding how many did come back, but it was small. The value of that was in the $1 to $3 million range of what came back because of what Mr. Finley said yesterday about the price to get them back across the border once you had put them permanently in Mexico.
But, well, maybe linked with that, yesterday when I asked a question, I think Mr. Melchem said that we still think that we still want a long-term investment in Mexico. Can they be used in this future expected or hoped long-term investment? I'm not sure it was Mr. Melchem or Mr. Finley.
I think it was Mr.
Or maybe Mr. Kenyon revendicates that. So it was said yesterday, and then at this, if the Mr. Kenyon's dream is realized, a long-term investment in Mexico again, can these equipment be used again?
those rigs they've been sitting there now for roughly eight years at the least, rusting. They would be inoperable. Since the contracts, since all the work stopped, the rigs have just been sitting there. So, and it was too expensive to bring them back.
Okay. I have two related questions, which are probably more to the claimants, but of course the respondent is free to answer if they want to. My question is, if I can reread me, if I am right, you complain that for the three contracts, and certainly for 81, Permex could have effectively possessed a right to the maximum, an entitlement, maybe more than a right, an entitlement to the maximum price. Is that true? And if it is not an entitlement, is right a better word? What is the word you would apply to the maximum amount?
When you make an investment like the ones that our clients did, you have to be prepared for the maximum. That's how these contracts operate. You need to bring the equipment there. You make a bid, and if you were to look at the bid documents, I don't know if they're in evidence, but if you look at the bid and the award for the bid, you'll see a certain number that corresponds with the maximum amount of the 821 contract. You have to be prepared to perform that amount of work, and that requires, under the contract, for you to bring a certain amount of equipment down there and be ready to go when that first work order comes. Does that answer your question?
Not entirely, because must you not also be prepared to the minimum? I think what you cannot be prepared to, I suppose, if I were an investor, is to have less than the minimum. But can't you just be prepared to both and not just to focus to the maximum, whether to be prepared or to get the money back?
No, because under the contract, Pemex had the right to issue work orders up to the maximum. So you had to be prepared to do all of the work that was required under the work orders up to $418.3 million. In addition, there were provisions that Mexico could have asked you to do more work, but you had to then consent to it. So you had to be prepared for the maximum. You had to make the investments in equipment, supplies, material, and people to fulfill the maximum amount under the contract, because the work orders could flow. And there are penalties if you fail to timely fulfill the work orders, as we've seen.
This I do not
Yes.
challenge. I have no doubt about that. What I have a doubt is on the expectations, the financial expectations, because, okay, you must be ready to provide what is requested by the orders at a maximum level, but they tell you in advance, we are not sure. So I suppose you have a difficult choice to make. Should I be prepared for the maximum? Should I be prepared for the minimum?
I think it's clear that Pemex expected that we, the claimants, were to be prepared for the maximum.
And you
And
were,
we did.
and you expected that you would be asked for the maximum.
I think that was a reasonable expectation, that we would be asked to do the claimants would be asked to do the maximum amount. But under the contract, we were required to fulfill the work orders or suffer penalty. So as a consequence of just the functioning of the contract, the maximum amount of work up to $418.3 million had to be anticipated, because we could get those work orders.
Okay. Another but different but related question. And what about Mexico for its part? Reading and listening to you, I sometimes had the impression that you demanded that they had the funds available for the whole of the contract, including the maximum.
Yes.
I am right, or?
Yes.
But if it was, that's for me not so much a legal issue, but a logical issue. Since they have only promised for the minimum, because if there is a maximum and a minimum, I suppose the state cannot be seen as promising more than the minimum. But why would it be binding on them or compulsory for them to have to be ready to have the money ready for the maximum?
I'm not sure why there was a compelling legal obligation for them to spend the maximum. Our expectation was that there would be funds available. And under the facts of our case, if in fact the facts of our case are viewed by the tribunal as true, that there was a manufactured work order that was used for an excuse to terminate the contract, then it's hard to understand why we wouldn't get the benefit of the maximum. When we made the investments, again, earlier there was reference, Mr. Lastano, to $200,000 a month to pay for certain personnel. That was a small part of the investments made. We made the investments to perform a contract for the benefit of Pemex under certain agreed terms. And as a consequence, we bought the equipment, supplies, material, and engaged the requisite number of personnel to fulfill that commitment.
This I have heard several times, and sometimes I understand what I am said. This point is well taken. But again, what is more troubling for me is that sometimes, listening to you, I had the impression that you reproach Pemex not to have the money available for the maximum. And this, I think, and I see some logic in the Pemex answer on that, that they say, well, we must have money to pay when we order the works. Why would they have money to pay when the work orders are not given?
Señor Presidente.
Mr. President.
To respond, sorry. Mr. Pillay, I think the answer to your question is almost at the beginning of, for example, the 821 contract, where it clearly says in 1.5, this is Exhibit C34, that Pemex tells us it has secured the funds to carry out the works that are the object of the contract. It wouldn't have written this if it didn't mean that it had $418 million to perform the maximum amount. And there's a process, and it's clear what the process is. before signing this particular contract, it got funds allocated to it by the Congress. This is why we asked you, and you all ordered, disclosure of those budgets, so we could show you. We could avoid this minimum, maximum. We could show you what the expectations of both sides were. Unfortunately, instead of getting those budgets, we were presented with consolidated financial statements of Pemex. And we were told, good luck, try to find it within, and you can't. Best of luck to you.
Señor Presidente.
Mr. President, just to add some elements in connection with the question that was posed by Mr. Pillay. If you look at C34, which is contract A21, if we look at clause 5, it is at page 15 in Spanish, and in English of this same file is page 101. The parties agreed that PEP should not be obligated to exercise the full amount of this contract. It is clearly stated in the contract. As Mr. Lustono said, this contract had minimum and maximum amounts, and the possibility existed for the maximum amount not to be reached as provided in paragraph 2 of clause 5 of the contract. That cannot be refuted. Thank you.
Muchas gracias. By the way, I've noticed now some slight inconsistency concerning paragraph 1.5 of the contract, because you use the word secured. In Spanish, the contract says "ha previsto," which is a term which is foreseen, is not as binding as secure. And in the English version of the contract, which appears at the very end in the second part of document C34, on page 94, there is another term, 1.5. You have provided the resources to carry out the work that is the subject of this contract. So, provided y previsto, in my view, are not identical. So, there's a measure here of ambiguity.
I'm not trying to mislead anyone in my interpretation of it. What could answer that question are the budgets that were allocated to Pemex for the 821 contract. And it would be readily clear to everyone in this room how much money Pemex received to be able to perform under this contract.
Yes, but in Spanish, because basically what you are arguing throughout this arbitration is that potential expenditure for revenue for PEP to spend in case the maximum was reached, it was a funded liability, a funded contingent liability. And that's my point, that in Spanish, when you say that you have foreseen the amount that you might require if you go to the maximum, in Spanish, that's not a funded liability. You have foreseen, so is you know how much it's going to cost you, but when the time comes, you will try to find the resources. It's like starting a trip. You foresee the average cost, but you may not have necessarily in your hand, in your pocket, the amount you will have to pay when the bills come due.
Exactly. Yeah. And
what I might suggest, that what perhaps I would like to hear, I would believe that probably 1.5 has to be read in conjunction with the applicable law, the applicable budgetary laws that exist that cover that provision 1.5. So that probably would inform me. That's the way I would look at it. Now that's probably out of negligence on my part, but have the parties submitted the appendix containing the definitions in Spanish? Because I see it only in English, and I'd like to know how trabajos is defined.
You'll find those definitions in R3
R3.
in Spanish. We then translated them into English.
Good, thank you.
I have still one or two questions. One is more for Bo. No, this one is done. For the respondent, how do you reconcile your position that the ILC draft Article 4 is not applicable with your position on attribution? Well, when I speak of the ILC, I imply that everybody knows this by heart as I do, but probably not. Article, you said no, Article 4 of the ILC, which is the main one, or one of the two main ones on attribution, is not applicable. How do you reconcile this with your position, if I understand it well, your rather insistent position, then Pemex and subsidiary are of an administrative nature?
Gracias, Profesor.
Thank you, Professor Pillay. I'm going to give the floor to Mr. Becker so he can answer this question.
Entendí que no, que
Let us think about the answer to your question, sir. Thank you.
Gracias, Profesor.
Thank you, Mr. Much and Mr. Pillay. I'm going to give the floor to Mr. Gary Shaw. He's going to assist us on this matter and provide some clarity to the tribunal. Mr. Shaw, you have the floor.
I believe Article 4 deals with organs of the state, and that's referring to agencies, ministries, entities that are directly controlled and 100% within the organization of the government. Other articles deal with semi-autonomous. Excuse me. Article 4 does not deal with semi-autonomous entities such as Pemex, commercial entities like Pemex.
Would you need the Nicaragua test, every action?
I'm sorry?
Would you need the Nicaragua test and to demand that each and every action is directed by the government?
I don't believe it. Explain that, if you don't mind. What are you referring to?
Well, the Nicaragua test comes from a case that I have brilliantly win in the public opinion and unfortunately lost if you look at the detail. The ICJ said that the U.S. government, the U.S. state, could be responsible for the action of the Contras, the opponents to the revolutionary governing Nicaragua, We were very happy with that. I was for Nicaragua. And then they said, yes, but every wrongful act must have been decided. The fact that there was globally a control is not enough. So the Nicaragua test means that you must take each breach one by one to attribute and know if this precise breach is attributable to the state in that matter. It was the USA. So if you transpose it to our case, the question is the state, the Mexican state, responsible because globally it controls Pemex, or must we go to each individual breach and see whether it was committed under the control, the direction of Pemex, the Pemex or the Mexican state, because in this part of your written argument, I think sometimes we don't exactly know what you're looking. But it's not my question. My question is, do we need a global control, or do we need that it has been, or is the Pemex every and all wrongful acts, reproached, alleged wrongful acts, must be directed by the state?
I think you would have to look at each breach individually, and it's our position that if you look at each of the alleged breaches in this case, none of those were in any way directed by Mexico. They are all commercial actions in nature.
Okay. Well, don't be astonished if I don't take note. I never take notes. I really read after, because otherwise I don't listen.
Señor Presidente, solo para...
Mr. President, just to add something to what's been said, clearly we would like to expand on this issue related to the Nicaragua test mentioned by Mr. Pellet. We will probably do that in our post-hearing briefs. Let us not forget that claimant is the one that alleges that Article 4 of the International Law Commission draft articles should be applicable to this case. We disagree with that. We disagree with that because we have a lex specialis and under NAFTA and under USMCA. So the burden to show that Pemex's acts are attributable to the state of Mexico, that burden is in the hands of the claimant under Article 4, but we would like to expand on this under the Nicaragua test as indicated by Mr. Pellet.
Thank you. I thought I had two more questions, but one I cannot understand what it is about, so maybe it comes back tomorrow. My last question is to both parties, and it is related to the USA presentation, to the US presentation last day. I would like to know if both of you agree with the very strong US assertion, which I have already heard elsewhere in the ICJ, do you agree with their position that the minimum standard is limited to a denial of justice? She was, I think, extremely strong on that. She said you cannot extend the minimum standard. Sometimes the minimum standard is just set to the classical minimum standard. Sometimes it is let's say, it is much wider than that. I will not tell you what is my position, but if you look at some arbitration, you can find it. But do you agree the minimum standard is denial of justice, full point. She said this, I think, very strongly.
Naturally, a host government is going to come in and try to give you the most narrow interpretation possible of what its obligations are for a minimum standard of treatment. Unfortunately for the United States, every other tribunal that I'm aware of has disagreed with it. It is not narrowly constricted to due process. So no, we do not agree.
Okay, you can look at the verbatim of the pleadings before the ICJ in the Iran versus U.S. case. They had exactly, the U.S. had exactly this same position. Just to say, it is not new. I've not invented that for your case. It's.
I would be, Professor Pillay, I would be surprised for the United States to come in and say, yes, we believe it has a very expansive interpretation.
I would be too. And I can tell you that if France was there, it will be the same. Anything from the...
En un segundo, Profesor Pillay. Gracias.
If you could give us just a moment, sir. Thank you.
Professor Pillay, I think the more narrow issue that's being addressed is how to apply Article 1105 in a circumstance in which the impugned measures are the judicial, the treatment by the courts. All right. And so in that case, yes, Mexico agrees that what's relevant in that context is only the denial of justice, because it is not, as we know from the Elsie case, it's not the role of the tribunal to second guess the merits of a court decision in the domestic proceedings. That's why the context is limited.
Well, this I have no problem to be with you, but this is not exactly the question. Is it limited to that? Usually, claimants prefer to have a wide view of, and respondent prefer to have a restricted one. But is it tenable to say that the FET, or the minimum standard is and can be limited, and is in this case limited to denial of justice?
In this case, because the impugned actions are the actions of the court, yes. I mean, one thing that I think is not in doubt, cannot be in doubt, is that Article 1105, the minimum standard of treatment, equates to the customary international law minimum standard of treatment. So typically in these cases, we get lots of arguments back and forth about, because there are some treaties, as you know, that are not limited to customary international law. And tribunals have applied what they call an autonomous, fair, and equitable treatment standard. But it's absolutely clear under the NAFTA that it has to be customary international law, because the Free Trade Commission issued a declaration to that effect, which is binding, and tribunals acknowledge that. So then what happens is the claimants then say, well, the standard has evolved over the years, and basically the customary international law is the same as the autonomous standard. You can just decide if you think something's unfair. And as you might imagine, Mexico disagrees strongly with that, as do other governments, right? The customary international law standard is very strict.
Well, let me be the devil advocate, at least certainly for you. Why didn't they write denial of justice in, and not this much more usual formula, minimum standard of FET? It would have been so much easier and clearer to say, this is the there must be a denial of no denial of justice, and why say there is no there must the decision must be in conformity with the minimum standard, and they say but minimum standard means something much more limited, and I think for me easier to be conceived, not always to be proved, but to be conceived, which would have been denial of justice.
Well, Professor Finley, with your patience, I think we'd prefer to address this in more detail in our post-hearing submission.
Fine.
Okay.
I just have one follow-up question. I just have one follow-up question on attribution. I heard before from you, Mr. Becker, I believe, or Mr. Bonfiglio, that you take the position that you shouldn't take an omnibus view, but you should, or a general view, you should establish attribution in each individual case when a breach takes place, right? That was your position. You look at each concrete individual case as to whether there is attribution or not.
The impugned actions, yes.
Correct, excuse me,
yes,
the
that's
impugned
what
actions.
Mr. Shaw discussed.
And then apologies. And then my next follow-up question is, you would also possibly, or your factional analysis may change over time, right? If you say impugned actions may change, I mean, there may have been an impugned action at one point in time, later on in time, and each time you would look also, it would be a different kind of attribution, different kind of sets of facts that you might look at, correct?
I believe so, yes.
Okay, yeah.
So we seems to be finished concerning issues of housekeeping, briefly. My question to the parties is, do you consider the timetable for tomorrow feasible and reasonable? Because if that were the case, probably we could decide to dispense altogether with Friday, and so that everybody, if you have the right rate, you can you can move forward your return, and so we would be finishing tomorrow in the evening. Is that agreed? So because in the tribunal we have made an effort to concentrate on our questions. Now, tomorrow there will be some definitely, but I think we can live within this with this timetable. So probably we can agree that Friday is off. We write it off as reserve day.
We welcome the opportunity to return back to Texas.
Okay. Then other questions is, well, the tribunal has informally agreed, but we'll formalize later on that we will be sending to you a list of questions for you to consider on a voluntary basis in your post-hearing briefs. That's one. Then something which is still open is whether there will be a limited phase of some additional submissions. That might include the 2 organizational charts for each party, and maybe, who knows, tomorrow we'll see whether claimants ask for an additional submission of alegatos or whatever. So, but my question is, could you talk to each other concerning the days you would need to submit the post-hearing briefs once all exchanges and are, so I don't know how many months or weeks you have in mind, but if you could give us an estimate so that we can easily come to the timetable for the post-hearing timetable.
Well, I don't want to play too much a bad guy, but I was not happy the decision we took yesterday because we lost one afternoon. Now it's 4:10. We are losing half an afternoon as well. So I just want to say very clearly that I don't want tomorrow to be pressed. Either we finish or we don't finish. But I really think that we did things which I disapproved, and I still disapprove, concerning the full afternoon lost yesterday for reasons which I don't really approve. And now we are going while the witnesses are here. Okay, I cannot oppose that, but tomorrow I want to be absolutely free to ask the questions I want, to get the answer I want, and not to be said, hey, we have a plane. My plane is to the day after anyway.
Then we have two possibilities: either to make tomorrow an open-ended session, and I don't know, with the stenographers, we agree with this perspective of going beyond the 7:10, or we still keep Fridays open. So I withdraw my suggestion, and for the time being, we keep Friday morning open in case we don't have enough time tomorrow.
Or we can start
Or tomorrow we are supposed to start at 8:30. Shall we?
I think we have.
Or we can start the cross-examination now.
It will be the tribunal the one to confer.
I think we have far less problem because if these are experts.
Well, you imposed this on me yesterday. Okay, but I was furious. I am staying.
Okay, I have to recant and withdraw my proposal to write Friday morning off. So for the time being, we keep it in reserve, just in case. And at some point tomorrow, we might decide. And then, as I told you, if you could speak to each other so that we have some idea about when post-hearing briefs might have to be filed. Anything else on the part of either you?
No, señor presidente, solo reiterar que...
No, Mr. President, just to reiterate that we are at your disposal for the time you need. That's what we're here for. Just to recapitulate, tomorrow we would begin at 8:30, correct?
Y la tarea que se llevan...
And the homework that the parties have is to consult regarding times for submitting post-hearing briefs, correct?
Well, yes, and y también los escritos de
Yes, and also the briefs on costs. Costs, post-hearing briefs. The thing is that the time period for the post-hearing briefs will begin depending, well, when it will depend on whether there's a new round of submissions, organizational charts, or if the tribunal were to admit it, new evidence that claimant might seek to introduce. But if we say X, it would be X plus how many days for the cost brief and for the post-hearing brief, so that tomorrow, by the end of the day, we should be able to have some idea. we could take that up during housekeeping matters on tomorrow's program. So I thank all of you.
Good evening. I just want to set the expectations. We're trying, but I cannot guarantee this aligato tomorrow. I just want to set the expectations appropriately.
But nonetheless, if you get it,
I promise you will be the first to know.
all right. So many thanks for your patience. We started very early today, 8, and so we'll see you again tomorrow at 8:30. Thanks.